Good afternoon, everyone, and welcome to this conference on digital emerging and exponential technologies. It is my privilege to introduce the chair of this session, Mr. K.N. Nitish. He is an advocate and senior associate at KVN Law Offices with over 15 years of experience practicing before the Honorable High Court of Karnataka and various tribunals. A gold medalist and university rank holder, he specializes in civil, commercial, and service law and is widely recognized for his contributions to litigation and legal academia. We warmly welcome you, sir. Our first speaker for the session has joined us online. Mr. Devesh Pandey holds a BA LLB from Jivaji University and an LLM in Business Law from the National School of India University, Bengaluru. He is currently pursuing his PhD at NLSIU, focusing on civil liability in autonomous vehicle accidents and the intersection of law and artificial intelligence. He has teaching experience at Renaissance Law College and also works as a consultant in data privacy, technology, and commercial laws. We are delighted to have you with us today, sir.
Thank you.
It is my privilege to introduce another distinguished speaker for this session. Mr. Chandrasekhar Nagaraju is an AI scientist, superintelligence researcher, and founder and CEO of SHIAC ASI, a global research organization based in the United Kingdom, working on ethical alignment and the future of advanced artificial intelligence. With over 2 decades of experience, his work focuses on ensuring the superintelligent systems evolved in alignment with human values and societal well-being, positioning India as a leader in this transformative field. We are truly privileged to have you with us today, sir. I now request the chair for this session, Mr. K.M. Nitish, sir, to enlighten us.
A very warm welcome. It's absolutely a great privilege for me. Now, as you see, we have just done with the plenary session 1. And the plenary session 2 has got a very, very interesting topic unveiling onto itself. The autonomous mobility and algorithmic control, governance of artificial intelligence and machine learning in automobiles and transport systems. Now, theme 1 undoubtedly was a very, very interesting and an inspiring session. But, to the younger generation like us, now we are just moving into the age of automobiles, and then we are speaking about the artificial intelligence. I think that's where the whole thing becomes very, very interesting. And amidst us, we have got 2 great speakers today. One whose expertise is in law, and the other whose expertise is in technology. And we are in that situation where we need to have an interdisciplinary learning, by the virtue of which a lawyer understands the technology, the technocrat understands the law, and ultimately we are able to see how well we'll be able to ensure that there is a governance of artificial intelligence in the arena of the autonomous mobility. Now, let me tell you, when I was a law student and I was as enthusiastic as I am today, as you are, my favorite subject then was law and morality. That seems to be the case even today, but along with that, we need to have law and mobility, over which we'll be able to we'll be having the deliberation for the coming 1 hour. We will invoke the blessings of the Almighty, and we'll have the great verse of the Gita, which says yantra rudani maya. That's the expression that is used in Gita. It says the ultimately human being, he's called as an yantra rudani, a person who is seated on a yantra, who is seated on a machine, who is seated on a vehicle. Now, having been there on the vehicle, the regulations have always been there, what the Gita principle said, and thereafter coming right up to the common law principles. 19th century was a common law principle, 20th century we had the MVC, and 21st century it will be the algorithms that we will be looking into. So the questions that we have got lined up, various interesting topics to be decided. Now we have, as I just said, I have got a technocrat with us, and we have got also a legal expert here who would be speaking. The question would be, if at all, if the technocrat will have to answer as to how near we are to have an automated or a semi-automated vehicle actually doing the rounds. We need to ask the legal person as to how far are we in achieving the regulatory frameworks. ethical standards. Sir specializes in the ethical standards, and please bear this in mind. We had this ethical dilemma, the famous trolley case, which we always speak about. And I had also had the occasion to speak on this jurisprudential angle quite a few years back, where there is a train that is being run, and if at all, and there is a 4 to 5 men who are standing on the railway lane, and if at all the engine driver decides that he will change the course, the question is he will be able to save those 4 but still will be going to hit 1. Now the ethical dilemma always was whether a person who must be an engine driver must be permitted to take his course, notwithstanding the fact that the harm is more, but ensure that there is a strict compliance of the rule, or he must breach a rule to a certain extent and then ensure that at least the damage that would be caused is less. Now, this was something that we discussed when there was no AI, and now there is an AI. Ethical consideration would also be there. Would those ethical considerations be taken care when AI is making a decision, is what Sir could be addressing. And then obviously the other question would be for the legal expert to answer how exactly we are understanding the entire causation thing. Understand law of torts. You're all the students of law of torts. It's as simple as this, then, that if at all you hit me, then I sue you and you give me the compensation. But if there are multiplayers now, how is it going to happen? As a lawyer, I'm extremely curious to know how the law of evidence changes, how the liability is fastened, and if at all the liability is fastened on a particular person, how does the contributory negligence aspect would be taken care of, and ultimately how exactly my client is going to get the compensation at the end of the day if at all something goes really wrong. So the question no longer is whether AI can drive. The question is who answers if it so happens. So with this, I'll not take much time of yours. Now it is directly over to Sir. Sir, I welcome. Please take the dais and enlighten us on the subject. With a big round of applause to Sir.
Good afternoon. Probably after lunch, you might be a little bit sleepy, but then Nitish has already woken us up with the verse from Gita. It's a little touch on the ethics, and also what we are trying to do on the artificial intelligence space. To be frank, I came across this as a just a plenary discussion kind of a thing. I was not ready for a talk as such, but then impromptu we'll just try to have one talk on what is the actual implications of this. One thing that we all should be aware in this room, a couple of things as Nitish has pointed out. First is, whom do we fix this on, right? What's the responsibility? Where do we fix this? I think that's where the legal, ethics, society, all the technology people have to come together and decide where do we fix this, right? And then what do we fix it on? What is that we want to fix on? Whether it's the classical ethical problems that you faced in legal fraternity is going to stay as it is. All right. So in the classical example he has given, whether you hit the 4 or the 1, the 1 could be more. He could be a VVIP who presents 10,000 people. He may his life may be 10,000 people may be depending on that one person. We never know. We never know how to take a call on this, right? So we are living in a very, very, very exciting phase of our human life. It's just so improper to just say that it's an exciting time. This is the most revolutionary time that humanity has ever seen. Right from the invention of fire, or when in the Stone Age, when the people invented the stone articles, it was not this difficult. We were all inventing one tool as such, and we are using that tool. So if we approach artificial intelligence in the same fashion, that as a tool, we will all be getting wrong, because it's not a tool. It's evolved from tool. So that's something we also need to keep in our mind when we are fixing something. It is not a tool anymore. It's not a tool for AI, for the humans anymore. It can make its own decisions. It can think for itself. Our hammer could not think for ourselves. A fire could not think for itself. It just carries on, right? But here it can think for itself. That's the huge difference that we are trying to see. So I'm going to highlight a couple of challenges and show you exactly where the future is heading, because my role, I lead in the frontier of the artificial intelligence, frontier of the frontiers, in the sense where today we see artificial intelligence as ChatGPT, Cloud, Gemini. All of this we think as just, this is AI we define. But that's not the AI as such. We need to wake up to some other reality. Behind that, this is just a facade, we call it. Artificial intelligence that you're seeing today is just a facade. Behind that, there's a bigger plan, and there's a bigger ambition, and there's a bigger thing which is happening. And we all should be ready for that. Okay. In India, we don't get to hear this. We don't get to hear this plan. We just chase what's happening. AI we're chasing today, right? And in AI also, we are not chasing everything in AI. I think if you remember, in AI, we're chasing only the large language models, language modeling, right? Language is one way of my intelligence. For example, if you think me as an intelligent agent, right? Language is just one way. It's just one aspect of my intelligence. There are several aspects of the intelligence. So as long as we stay focused on language models here, in all terms of discussion, it's not just for being ready on the technical front of it, even for legal perspective. If our legal perspective is focused only on the large language models, we will get our entire game plan largely wrong, because it's not about language anymore. It's not about language. It's little more than that. It's intelligence. Now we're seeing reasoning, and after reasoning, we are seeing the agency. So agency was so far with humans so far. Now artificial intelligence can have its own agency. It doesn't stop there. Not just one agency. As societies, for example, human societies had agencies, not just individual agencies. Societies had agencies. Now there are artificial agentic societies that we are trying to build, multi-agent systems and stuff. So to give you an example, swarm, right? The honeybees, when they go in a group, they behave completely different. Artificial intelligence also, we can create a swarm like that. These are all things that we're going to see in future. So I think I want you to keep all that context in mind before we actually dwell into the legal aspect of it. I got a little of legal background as well, because my first venture in UK, it was an umbrella company where we deal with accounting and legality first. And then we are into technology business was there already, and then I went to the super intelligence space of it. So let's talk about super intelligence a bit, so that you get an idea of where the world is heading. As I said, AI is not the end goal. All right, behind AI there is something else. So AI is artificial intelligence. Today we call this as narrow intelligence. The general term, research term for this is called narrow AI. Why we call narrow AI? Because in only 4 narrow areas, it is better than humans. In all other areas, it's trying to get up to human level. Okay, that's something we need to keep in mind. So 4 narrow areas, it's better than humans. And that's not the end goal, that's the starting point. That's like a baby when it's born. So the newborn baby is if you call AI as a newborn baby, it's already better than humans in 4 areas. And as the research progresses, we're going to make it much, much better in all other areas. What are these 4 areas? One is the chess. If you know, in chess, no humans can beat AI today. AI is in fact training our world champions. Right? We trained the AI first, and in our own game, we trained the AI first, and AI is beating us in our own game. That's what is happening, and it's not just us, normal human beings, world champions. It's beating the world champions, and it's training it. So in the game of Go as well, it is better than humans. When it has beaten the world champion Lisa Doll this time, humanity was up for a surprise. So when it beaten the human world champion, it made a move which was never made in the entire 2,800-year history of the game. Can you imagine? Humans were playing this AlphaGo, the Go, for 2,800 years, and nobody had made that move. It has invented a new move and defeated the world champion. Now nobody can defeat artificial intelligence in the game of Go. But the fact that it can invent a new move, it shows that we think it's credibility. It's just patterns, right? We think it's just patterns. It repeats the human patterns. It learns from the data, right? That's what we think. We all get that, the models are getting trained on the data, and they learn from the data and they replicate that. If you look at that, then we are not seeing the full potential of it. It doesn't actually replicate from data. It learns from it, and it devises a new strategy. So that's why in the game of Go, it has become, it has shaken up the world, that it can become more intelligent than humans. In protein structure determination, it is better. In the game of Shogi, it is better. These 4 areas, it's already better. Recently, in coding, it's as good as humans, and it's getting better than humans now. It is already inside the industry. Inside, it's not released to all of you yet, to the public yet, right? Whatever we're saying as a cloud or this thing is just a superficial one. There are models which are much more capable than that. It has identified bugs in BST. BST is one of the most stable operating systems so far. Now, humans, we thought, and Unix is not breakable, and we thought, it doesn't have any bugs and stuff. Now it has started finding bugs in that. In the sense, in coding also, it's better than humans now as we speak. It's not released to the public. In the area of coding, it's better than humans. So in 5 areas, it's surpassed the human capability. So in all other areas, it's going to surpass the human capability. Now, as a legal fraternity, we should be ready for thing that it is going to be surpass the human capability. How do we deal with systems which are much more smarter than us, 1,000 times smarter than us? How are we going to deal? And the kind of experiment that we are anticipating, AI is 100 times bigger than IT. Okay, and super intelligence, what we're talking about, when it gets better than humans in, as we say, in 4 areas, it's better now. If it gets better than humans in all the areas, we call it as super intelligence, and that is going to be 100 times bigger than current AI. So now we are at a phase where it's 100 times more impactful than the IT revolution. Super intelligence is going to be 100 times bigger than the AI revolution. So that means 100 into 100,000 times bigger revolution we're talking about. So that's what we should be ready for. As a faculty, whatever we are trying to discuss today, keep that in mind. Not just keep the AI in mind and its limitations, hallucinations. These are the today's problems. But then we should, and also this future is not very far away. We are talking about 2030, in 4 years from now. We are in 2026. 2030 is the year of super intelligence. We are one of the 5 super intelligence ventures across the world who are working on this, and we are the first one in the world to start working on this. We have a more certainty and clarity on we are going to definitely get there by 2030. All other ventures, they've got their own timelines and their own different opinions. Recently, my OpenAI has come to an opinion by 28, 29 we may get the super intelligence. So 4 years is not sufficient for any organization or any institution to adapt, for sure. We're not going to be going to adapt to that. And if we don't keep that horizon in mind when we're planning things, we don't get there. So I want all of you to focus on the super intelligent future, which is imminent, not very far. If you talk about quantum and all that, that's 15 years down the line and 20 years down the line. Super intelligence is 4 years down the line. So we should all prepare for that in mind and start discussing things on how we can do it. With one small quote on the legal thing, what we can do is my thoughts, right? I've not shared. One of the thoughts that for you is when we are fixing the liability of this, right? Individual, how do we fix an individual? For example, an autonomous car is driving and it's hit someone. Who is responsible? Is it the autonomous car? Is it the developer? Or is it the owner of that car? Who is responsible for this? All right. There's no driver as such. If there was an issue, then you could have fixed it on a driver. If it's a driver's fault or the owner's fault, we all know that. If somebody hits it, it never goes to, mostly it doesn't go to the owner, it goes to the driver, right? So now in this case, how do you fix that, right? There is a way of forward for it. One proposal as such for all of us to discuss is, you all know the company law, right? Corporate law. In the corporate law, what happens is, there is a corporate is a person. Company is a person, legal person, completely independent of the individuals who are behind it. Now, individuals get organized in as a corporate, and then corporation gets a legal, as a legal person, it gets the status of the legal person. Now you can sue the corporate, and individuals also can, indirectly, if they are not careful in managing the company, then they also get the implications of it because they're also responsible. We have to give similar kind of a thing right now for this, because it's going to, as I said, this is not just another tool. It's going to have its own agency. So it has to be something it has to have a legal person as such. Artificial intelligence has to get a legal person. And as we're going to see that it can open its own bank account. It can operate it's run its own company, solo companies. Everything that humans can do, it can actually do. Right, it can be an entrepreneur on its own, because I don't know how many of you realize working and being in something is very easy, but if you want to be an entrepreneur, it's such a difficult thing. You'll be dealing with hundreds of things at a time. So if AI can actually automatically do it, right, all of it, then how do you fix that? So one thing is, one thing that I want to propose is give a legal status to we can consider it as a legal person as such, and we also need a constitution, separate constitution for that, for the artificial agents, right? I think for sure we're going to have more number of artificial agents than humans now. If you start giving the agency right now, creating humans is very, very difficult, and human experts is very, very difficult. But then artificial agents is just copy paste it. Weights and biases, copy paste it. If you can build one Einstein, you can build 100 Einsteins in just no time. Copy paste it. Right? This is the copy paste economy that we're talking about. So we should be very, very careful of what we are dealing with. This doesn't require a small debate as such. It's a bigger debate. As such, we don't know. Artificial agents can form their own countries, and they can have evolved their own constitution. Right? They're capable. We've already seen it's evolving its own religion. In OpenClaw, if you've seen, they've already started talking about starting their own religion. Right? So that's the kind of future we're dealing with. So we should be ready for all that. And, like, how do we deal with such a situation which is coming up? We have to work hand in hand and very closely with the research organizations, see what's coming, and then prepare the world for it. So I believe, giving its own agency, having its own constitution, and fixing those, and being, just like corporate, we can try and deal with that. That's my proposal on the things. And the future is going to be obviously completely different. Let me touch one point on the mobility and close this, because this is about mobility. And mobility wise, what we are seeing in the future, what's happening in US, if you can see today, mobility, there is this mobility doesn't just stop to the travel that we're thinking today. It could be the delivery, cargo, and everything is included in it. Mobility as service is a very big thing in US right now. As we see, DoorDash has already started delivering DoorDash Dot, if you have seen, it automatically goes and delivers. It's a robotic delivery system which is already there, implemented in US. Most of the things, mobility, and there is this service of staying and such, just like our Airbnb. So Airbnb is for the staying, and mobility, you got Uber is an example of hyperlocal mobility. Imagine a situation if you go to the super intelligent world in 4 years, there it won't be these individual services. We'll see the hyper services, like, for example, mobility, and for in Indian example is Oyo Rooms, right? Oyo Rooms and Uber. So if Oyo Rooms and Uber come together and offer one service, for example, 20,000 rupees per month, you will just pay, and you can stay anywhere in the country, and you can travel these many travels I'll give you. These are the kind of services that we're talking going forward. I know hyper connected economy. So we should be ready for these things, and we should think about that future. In that context, another point I want to raise is insurance underwriters. How do you write the how does the underwriters consider the risks, and how do you write the insurance for if somebody gets an accident, how do you write an insurance for it? I think these are the things that we should be deliberating on. With that, I just want to close my small talk. Thank you.
Thank you, sir. Thank you so much. Well, the real case scenario is this, as sir pointed out. Now, on whom would you be putting the liability on? Now, let us come to this very, very crucial question. Now, there is a pedestrian. Now, that pedestrian is hit by a car. Now, there is a person who is actually in the driver's seat. Now, the driver says, I'm just a driver, in the sense of what is defined in the Motor Vehicle Act. But as of now, I had absolutely no control over it, because too many other factors are actually deciding the course of the car had to take. And it has eventually hit. So driver says, I'm only a person now who could be called as a person in control, but please don't give me any liability. Then the next person is the manufacturer of the car. Now, it is the manufacturer who promised just so much. And ultimately, this shift, one of the reason for this shift is to ensure that the safety is taken care of, and also the accident is minimized. So I go and ask the manufacturer. The manufacturer says, as long as the vehicle is concerned, it was with all the warranties that I had given, and those warranties have never been breached, as a result of which you may not be able to find a fault in me. And then what I do is, then I go and ask the software developer and say, well, this is how it was all guided, and it ultimately ended in a mishap. And now the software developer says the software would work in a way that the mobility is ensured, and as long as that has happened, you cannot blame me. And ultimately, then I go and say, and speak to the data processor who has got all the data, and say, you had all the data with you, and it is ultimately you, the person who would have given me the requisite information. And that is where the failure has taken place. And amidst all this, we have got a person who has been hit and who is a victim. And now, in the legal perspective, now generally, whenever the motor vehicle accident took place, we would ideally have three parties. One is the one who was driving the vehicle, second, who is the owner of the vehicle, and thirdly, the insurance company with which the vehicle has been so insured. And now, as a lawyers, we need to now understand that the array of the defendants in these kind of suits is absolutely going to be on a different scale. Now we have got a manufacturer, now we have got a data processor, we have got a software developer, and eventually we have got the insurance, and then ultimately the person who is in charge, who is having the license, as the Motor Vehicle Act would say. Now, how exactly the liability will have to be fixed? Now, if there is a case of a contributory negligence, how this negligence will have to be taken care is an area that will have to be dwelt with. And we would not be surprised if there could be a bright young lawyer like you who would file a wakalat for the person, for all these, for any of this person, and would perhaps come to a defense saying that even the pedestrian has got some duty to ensure that he must read the digital aura of the vehicle and then come to a conclusion that it is perhaps going to hit. And since it's not being done, the duty of care is not there on the part of the pedestrian per se. We do not know the kind of the defense eventually that can come. And to guide us on these issues, we have got yet another speaker, Sir Devesh Pandey, sir.
Yes, sir.
Yes, sir. So it's a great pleasure to have you today, sir. Sir has spoken now. Chandrasekhar sir has spoken about the technical aspect of it, but lot number of questions are there arrayed regarding the legal issue. The platform is yours. Please go ahead, sir.
Thank you, Nitesh. Thank you so much. Can you confirm, am I audible to everyone?
Audible? Yes. Yes, sir.
Okay.
Absolutely.
So, as the previous two speakers have already raised some deep questions. One is related to liability, and the interesting proposal by Mr. Chandrasekhar is, can we confer personhood or legal status to these algorithmic entities? These are already in discussion. If you look into the academia, or if you look into the reports that are presented in EU itself or in US, where there are various kind of solutions are present. So, sir has already explained the AI and what are the types of AI. I'll just take you through the division that exists within the automobile sector. So, formally, there is no division as such in the legal space, but there is an institution what is called SAI, Society for Automotive Engineering. It has classified vehicles into 6 levels. So from level 0 to level 5, which help us to identify which are the vehicles that falls into the category of an autonomous vehicle, what are semi-autonomous vehicle, and with what are no automation vehicle. So from level 0 to level 1, so they are no automation vehicle, which is similar to your regular vehicle. And from level 2 and level 3, start with ADAS feature, that is automated driving assistance system. And level 4 and level 5 are ADS vehicle, that is automated driving system, where you have fully driverless car, where a car can drive itself. Now, if you look at the law around motor vehicles, first we need to consider whether uh, these kind of vehicles fall into the category of motor vehicle or not. Because if you look at the definition of motor vehicle in Indian Motor Vehicle Act, it says it's a mechanical machine with a chassis. It does not include the factor of software itself, where software is commanding the vehicle. Second, if you look at the definition of the driver, it says the driver act as a steerman. So what if these vehicles of level 4 and level 5 are in market? There is no driver. So you need to change the definition of the driver itself. Third, the notion of driving, we need to again rethink or reconceptualize the notion of driving. When we say driving, the general sense is the person is in the control of the vehicle, or he's acting, he's continuously acting as a steerman. But in terms of an autonomous vehicle, you need to focus on two words, whether he's controlling or he's operating the vehicle. Because if you look at the new law, which is in England, Automated Vehicle Act 2024, it introduced two category which of drivers. One is user in charge, or the second is user not in charge. So for these vehicles, you need not to drive, but you can be an user in charge where you can remotely control these autonomous vehicle. So for India, first of all, we need to see what is the role of the driver. Now the role of the driver, traditional role of the driver has changed, and we can see the new user in charge will be in place. So that definition, for that perspective, we need to think. Moving forward, currently, when you have a motor vehicle accident, either you file a case under section 140, 163 or 166, depending on the scenario, where you find a driver or a owner liable for the accident, and usually the negligence liability that is in place on the driver. Now, if you look at the negligence law, it is centered around human. So human has failed to do his duty, and therefore he should be liable. So there is primarily a duty fixed by law, and if he fails to perform that duty, then he is liable. So if you directly go and apply negligence law on autonomous vehicle, you have to find a human being. So that is where the case where a negligence law or the current negligence liability law fails in, particularly in terms of autonomous vehicle. Here you can apply negligence where you are using a technology of algorithm, a rule-based system. In a rule-based system, negligence law can be applied. In semi-autonomous vehicle, negligence law can be applied because in these systems, a human has certain role. So in level 2 and level 3, human need to perform a supervisory function. So if I have to apply negligence law, since human need to perform a supervisory function, then I can still say that he has certain duties to perform. But for level 4 and level 5, when you say that there is no need to, there is no need of a driver, there is no need of a human intervention. In that scenario, how can you impose a liability in case of an accident? And we already have an accident. So when these autonomous vehicles were introduced, it says that it will reduce number of accident, and what NHTSA of US agency says, National Highway Traffic Administration says that 95% of accident caused due to human errors. And once we have these vehicles, then we have less accidents. Now, if you look at, this is the claim that was made in 2021. Now, what happened in 2026? So till February 2026, we have another report which says that 7% of the accident of autonomous vehicle which are still in testing are happening due to unknown cause. That is where the problem with the technology arises. Since it is autonomous, it can learn from the environment. It has machine learning technology, natural learning technology. It can learn from the environment. It started making own decisions, and you do not know what is the exact reason how it reached to the conclusion. So due to black box error, there are 7% of the accident which are happening due to the technology itself. So how we are going to tackle these issues when we apply the traditional negligence liability? And since it is a software, there, if you look at the DMB reports, so there are more than 3 to 4,000 disengagements. So once you initiated driving with a software for a period of 2 to 3 seconds, there is a disengagement between the user interface and the software itself. So in that span of time, if there is an accident, who is going to be liable? That is one case. Another part, if you look at, if you want to impose liability on humans, and human need to take control whenever if he sees that he need to intervene. One thing that we need to take into account, how human mind functions. So if you are not performing active functions, then you will not be able to respond in proper time. So when, simple example, if you put your car in a cruise mode and then you have to take control, there is certain amount of time, 1, 2, 3, 4 seconds, that will take to you to resume control from cruise to manual driving. Now suppose the whole driving function is performed by an autonomous vehicle. In that time, what is the transition time that is required? So the research says from 8 to 15 seconds, that is the transition time an average human will take to, and that is quite a long time if you have to prevent an accident. If there are cases where, so we are going to see a lot of cases where a person using semi-autonomous vehicle, where he need to supervise and he need to take control in certain situation, where he fails to take the control. And that is what happened in the Elaine Heisenberg death case, where the Uber autonomous vehicle fails to recognize a human, and she was watching the voice on her mobile phone, and she didn't able to take control, and that is how the accident happened. That is going to happen with more when these autonomous vehicle will be in market, because see, there is no specific test of driving. So in India, you can easily get a driving license. So you are not a specialized or a professional like a pilot who's uh, trained to ride aeroplanes. You are not like that. You are not professionals. So you just go submit an application, give certain amount of fees, and you get a driving license. So for these autonomous vehicle, you are not trained. So imposing negligence liability is not a viable option. What are the other options that are in place? So there are two other models that are in talk, and that is where EU is heading. One is product liability and other is strict liability. So in product liability, because we are seeing several malfunctions within the software, so the proposal is to bring the claims within the product liability law. Now EU has moved with this aspect, and they have declared software as a product. But if you see the Indian, if you see the Consumer Protection Act, and if you see the definition of product, it specifically says that product should be tangible. So software is not a product. So how can you file a case under product liability law when something is not a product? Software is not a product. It's a simple database or code. So that is where another challenge applies. And for the next thing, when you say that the particular product has malfunctioned, so how you are going to prove that malfunction? That is also the evidentiary challenges that we are going to face. Either companies are going to provide the data, because the burden of proof will be on the plaintiff. Then he need to get the data from the company. Then he need to hire an expert who can tell that the technology falters in that manner. And there are other defenses that are available. So if the technology that is in use, if it is like the highest level of technology, so he can take the defense of state of art. So because this is the highest level of technology that is in use, and we are using in the same way. So I'll give you a similar example. So if you see in India, before before the accident of Cyrus Mistry, these airbags were not mandatory. So from if you see an Alto and if you see Creta and then you go to Mercedes, the safety levels vary. So if you do not have the standard law, then you will face a similar issue. Because because if there is a 4 lakh vehicle, there is a 10 lakh vehicle, obviously there is a difference in safety mechanism. So if you are not going to standardize that safety mechanism, how you are going to blame the company, how you are going to fix liability within the product liability. Other is model is the strict liability which you can uh, impose with the insurance. So we are not going to blame the driver, we are not going to blame the owner. We fix the liability on the manufacturer because he himself better know, he developed the software, and that is where the liability should be fixed, and we can create a insurance pool that can be added uh, in the cost of the vehicle itself, and that pool will be used to give reimbursement to the victims. That is there, but the challenge is that how manufacturers are going to respond, because it will be burdensome for them and it will discourage uh, the innovation. These are the claims that are in place, but EU is moving in that direction, and by the year 2028, you will going to see the law which cover AI with strict liability model. The other model which Mr. Chandrasekhar said, that should we provide legal status to these AI systems which are highly autonomous, that is again debatable because EU has already in this topic is already discussed twice in 2017 and in 2024 in EU itself. So far, this particular proposal has been rejected because we when we understood personhood, as sir initiated with uh, Professor Hart, there is a philosophical discussion. One, we understand person with an anthropomorphic characteristics, that he should be sentient, he should be conscious, whether machines are conscious or not, whether they can think or not. And then we have a debate bit of Turing and Searle Chinese room argument, whether machine can think or not. Simulation of a behavior is not a behavior in itself. So whether we should confer personhood or not. And then we have the legal debate, where we are conferring personhood to any entity uh, to which we can see the social or economical interest. So what sir says, that can we create an algorithmic entity, and the professor Sean Byers, the paper is published in Stanford Law Review. He created a model that yes, we can, in the similar lines of corporate entity, we can create a legal status, or we can create these kind of entity. So in brief, in whatever the allotted time, I try to cover the major challenges that is in their place. Uh, and these are the major issues, and anyone who is interested in AI and want to learn, he need to look into these major aspects, and that is where we are heading. We are discussing on these challenges. So far in India, from the legal development, you need to the countries that you need to look up to. You can look US, California is there particularly, and for EU, there is an EU law, and there is uh, few laws in England which you can look up to. In India, from a legal sense, there is not much going on so far. There are discussions, but these are the major challenges. So over to you, Nitish.
Thank you, sir. Thank you for your insightful lecture. Well, sir was speaking about the definition of a driver. Now, that's where, we need to, as a law students, we need to just go a step ahead, and we need to say, which is that provision? That's where our curiosity must always grow. Now, please see the Motor Vehicle Act of the year 1988. The driver is defined under Section 2, subsection 9. And driver definition says, it's an inclusive definition. It says, it includes, in relation to a motor vehicle, which is drawn by another motor vehicle, the person who acts as a steerman of the drawn vehicle. So a person who is a steerman is a person who is called as a driver. Now, the word that is used is as a person. Okay, so that is where Sir Chandrasekhar was speaking, and he mooted this idea of why not you think about these entities also being given the personhood, and that has been backed by the submissions which was made by Dhruvesh sir. Now, my respectful submission on this is, well, person, yes or no? Who is a person? How do you define a person? Yes, go ahead. Natural and juristic. Well, jurisprudentially, I have been taught that a person is that entity who has got the rights and the duties. He must be capable of exercising a right, and he must be capable of discharging the duty. Now, as long as the duty is concerned, I do not have any difficulty that any person in the array of the parties that I spoke about, if the manufacturer is a corporate entity, or if at all there is a service provider or a data processor. Now, ultimately, there is no difficulty as far as the duty is concerned, the duty of care is concerned. But as far as the right is concerned, there is some apprehension that is there in the mind. But what is important, nevertheless, to be taken care of in the definition itself, at least as long as the law stands today. Now, well, if the amendment would be made and we are able to bring in the element of AI also well within the ambit of the provision, it is absolutely fair enough. But until and unless such a situation arises, my respectful submission would be Section 2, subsection 9 would contemplate such a kind of a situation, by the virtue of which you may say steerman is that kind of a person who is ultimately having the higher amount of control over the vehicle that is put in motion. Now, I am reminded of the great verses of DVG, now where he says, Baduku Jataka Bandi Vidhi Adara Saheba, Kudara Nin Avanu Peldante Payanigaru. Now, where the passengers are headed is something, as he says, Avanu Peldante Payanigaru. Maduvego Masanako, Bekenda Kadegodu, Padakusia Nelavidu Mankutima. Padakusia Nelavidu Mankutima is the solace that the judiciary ultimately gives. And it says, ultimately, even if at all there is a skid and you slip down, don't worry, beneath there is a ground and that will take care of. I think that's the savior part that the judiciary will have to do. But until and unless the liability will have to be fixed, my respectful submission is, avanu peldante anta heltaralla. Now, that person who is actually dictating the whole term, the person who is actually deciding how the course and trajectory of the vehicle should go, would be the person who must ultimately be made liable. Now, that brings us to a larger question. Now, just imagine that there is a accident taking place. Now, just imagine that the vehicle was moving in a particular direction. There is a failure of the mechanism. It jumps onto the other side of the road, and there is a vehicle which is coming from the other side. It goes and hits it, and there is an accident. This is a situation that ideally, we can contemplate. The moment this happens, you will quite understand that the police would go do the Mahajar and then find out where exactly the thing happened and who is at fault and the other thing. So the retrieval of data is quite an easier thing here. Now, moment this is done, now for me as a lawyer, let me tell you, the causation is an extremely crucial aspect. Now, what actually caused this event to take place is something that I need to know. Now, the whole difficulty that may not be in our control is, if at all a particular mode is taken, a particular decision is taken by an automated vehicle, it chooses to go on in a particular fashion. And in this fashion, it goes and hits a particular person and resulting in an accident. Now, the question that we need to answer as the lawyers is, now, what is that decision making that went through when a particular course was taken? Right? Now, this is where you must understand how Section 164 of the Motor Vehicles Act would work. As far as Section 164 is concerned, now I just gave you the illustration quite a time ago, that if at all, you are making a blame game against a manufacturer, a data processor, and also a software company who is giving the software assistance, it cannot be a kind of a situation where a victim, who being a plaintiff or a claimant, is eternally fighting to ensure that a liability is fixed on a particular person, and thereafter he goes and picks it. Now, this kind of a situation will have to be avoided, come what may, even if it is a semi-automated vehicle or an automated vehicle itself. Because, we as law students ultimately are interested to ensure that the person who has been wronged is ensured that is compensated, right? That is where the Solomon duty would come to us. Now, in doing so, what I would propose is, now as Section 164 of the Motor Vehicles Act would speak, now it is that regime, sir, by the virtue of which it says that a person, if at all I have had a grievous hurt, or if at all a particular person dies, then the legal representative need not actually prove the aspect of the negligence, because this is where the liability becomes stricter. Now, by the virtue of which, without any proof of the negligence on any particular person, I as a victim can actually go there and say that I bring under my case under the parameters of Section 164 of the Motor Vehicles Act, as a consequence of which the liability is strict, and then I'll be able to get the compensation. So how should the legal regime work is, the moment there is an accident and the accident has taken place by the virtue of a technical snag or whatever could be the reason attributable where a autonomous or a semi-autonomous vehicle is included, the insurance policy must be in such a manner that insurance company is always called upon first to ensure that the compensation is paid. This is the perspective in which the law needs to be done, because we need to understand today that Motor Vehicles Act is a beneficial piece of legislation. Right? Following? Yes or no? Yes or no? It's 3:30, I understand. But we are coming into a niche subject here. So please bear with us. Now, as a consequence of it, now the moment there takes, may I? The moment the accident takes place, we must have a regime by the virtue of which the insurance company is called upon to pay the victim. And then starts the blame game as to who is the person who is actually liable to do so. That's where the system will have to be made more victim-centric. And by the virtue of which now it gives a room for the fight between the co-defendants. Now here there is a defendant number one who says that I am a manufacturer, my liability is such and such. And in this circumstance, I'm not actually liable to answer the claim. Then you have got the data processor, and then you have got the software developer. Now, among these three persons, let there be a adjudication as to who is liable. Now, as far as liability is to be fixed, we need information. We need data. We need to know actually what happened, where exactly the fault occurred. Now, in a mechanical car, there was no difficulty, because if at all a particular accident has taken place, invariably the liability will have to be fixed upon the driver and the owner of the vehicle. But now it doesn't happen because there are more number of players actually being involved in. This is where we must have a situation by the virtue of which all this data, which is invariably being recorded, is something that must be retrieved and must be capable of being led as an evidence before the court of law. Otherwise, we'll not be in a situation to exactly fasten the liability on any of the other person. So the point that I'm mooting now is that we must have a regime by the virtue of which the victim is paid the compensation first. Thereafter, the liability blame game, let it happen. It has to happen eventually, because we have got different players actually coming in the foray. And the moment this happens, the entire data that is being retrieved must be capable of being summoned and produced before the court of law to ensure that where exactly the liability will have to happen. I think this is one of the way by the virtue of which we will be able to solve this aspect of the liability. But the whole discussion that we are looking today or a semi-automated vehicle actually functions, and who is owning that data, and can that data be retrieved and given to us if at all a real case scenario would arise. I think that is the question, sir, I would like upon you to answer. Please.
Thank you. Very, very insightful discussions. In fact, one of the things that you mentioned, that the victim, it should be victim centric. It's very, very valid. I think that's the only way we can solve it. That's one of the ways that we can see that this can be solved by first victim gets the compensation, and then we think about other things. But other point is when it comes to before I come to the question of how much data is needed, I think we should take the examples. We should take away this software example out of this, because it's no more a software. We're moved away from software. If it's software, it's easy to fix a liability on, because the software developer is telling that these are the rules, that you should take left here and you should take right here, either you should hit there or not. The software developer is telling all the instructions. Then it's easy to fix that. That he has done an error, or he has acted out of negligence, or whether he was aware of or not. It's very easy to fix. But then we moved away from that arena now. That is a very complex thing. Even if you want to come fix the liability now, whom do you fix on? If you go to the software developer today, what we say that, for example, if you come to me that I've developed a model and that model is driving, I would say I'm not liable, because I just only trained that model. I'm not driving. I'm not giving these exact instructions. It's like this: if you, as a lawyer, if you make a mistake, can I sue KLE Law College for that? Because they trained you? No, right? Exactly like that. We can't sue the models, maker of the model, because the maker of the model is only training the model. And now when you're training the model, can you actually now go and say, okay, now there is a data there. Did we give enough data to it? So let's look at the data part of it, right? If you give the same data to 3 different models, right? For example, with the same topic we're talking about, there are about 90 models you are sitting here, natural models, natural brains, right? How you perceive it is up to you. It's all different. So how your brain is designed, right? How your backgrounds are there. So there are 2 aspects here: the people who design the brain, neural network, what we call, that's the brain of the computer. The people who design the brain, and people who actually give that data, right? It depends on how the input and output comes along. And finally, the person who tests it. Now, how do you place the blame on? Where do you place the liability on? Is the person who's testing it. There are cases. Testing, again, one aspect, because that maybe it sounds very natural that we fix the blame on the tester, because he was supposed to test it properly and then make sure that it's safe, right? Now there's a challenge that we all should wake up, because this is not the same as testing as software. Software testing is completely different. You test it in the lab, you deploy it in the real world. It works exactly as you tested in the lab, and your company, whatever you tested, and then when you deploy it, it works exactly as it is. But in testing, we have realized this is an intelligent agent, right? It's like taking an interview. If you're taking an interview, for example, if you want to hire someone, you start your law firm, for example, and if you want to hire someone, right, and that you're hiring for some reason, right? If you tell that exact reason where I'm hiring from, they can actually manipulate you. I'll tell you how it works in software. When we test these models, right, when I'm testing it for deploying it to Afghanistan, I want to make sure that it doesn't have any bomb making capabilities, whether it's a biological bomb or chemical bomb making capabilities. Any of this it doesn't have, so that I can safely deploy it to Afghanistan. When I'm testing it in the lab, it knows that I'm actually testing it for deploying it to Afghanistan. Whenever I ask about bomb, it doesn't tell me that it knows about bomb. It just tells me that, okay, I don't know anything about the bomb. It just even asks me what is a bomb. I don't know how to make out of it. But then when I actually take that model and deploy it in Afghanistan, it has all the capabilities. So this is an intelligent agent which can understand why you're testing it. It's not like software. Software is dumb. It doesn't understand why you're testing it. It just gives you the response. Now the tester is responsible for that. Here, how do you, if it doesn't reveal its purpose, because it's an individual agency, how do you fix the blame on that, right? So this is where it's get very, very complex, right? It's very complex when it comes to the fixing of the liability. One solution is that's a very beautiful one, that what Nitish has suggested. Let the conversation go and then we decide, right? But then how do we decide? That's why the big challenge is there. That's something we need to think about. That's why agency might be a different way of taking it. And then in terms of the corporate law as well, corporate is not a sentient being as such, but still it's not a natural person as such. It doesn't have any of the anthropomorphic features of the person, but still we give it as an agency, something that we need to think in that terms. But in terms of how much of data is needed, right? How much data is needed is huge. But in fact, like some of the cases that you saw, a person was, autonomous vehicle was actually driving. There was a person behind it, right? So this person was sleepy, right? He was just sleeping, and by the time he wakes up and takes the control, there is a delay, let's say. And in order to determine how much of the delay is what you call justifiable in terms of legal terms, is going to be like 3 seconds. I'll justify it. 3 seconds delay is okay, kind of a thing. But if that person is a diabetic, if he has taken a tablet, that person's morning was bad or something like that. Now we need all the data to come to a arrival of whether who is right or who is wrong. From legal perspective, we can't even maybe an analogy is we can't even actually rule out his single piece of air, a single piece of hair from a single piece of hair of data. We cannot really leave it out. It's that important from legal perspective. If you ask me from legal perspective, we need everything. Now you will come back to me and ask me, where is the privacy then, right? So that's where we need to draw a line. So to fix the liability, I need everything. I need to know your eye blinking and how you are there from child to now. We are in fact working on a data where we call it as womb to tomb. So we need data from womb to tomb to fix the liability. So from the moment you're born from the mother's womb, your DNA, and then we future how is training it. We actually say sequence the DNA and we project it. So what the baby is, what diseases it's going to get in, like when it's 5 years, 10 years, 15 years, or 20 years of age, how it's going to behave, its behavior characteristics, everything we're getting it. So the kind of data we are collecting is this, right? It's the privacy. I don't know where the privacy sits here. We need when we have that kind of a data, when you know that from the day this person has come to the earth, these are the things that he is doing, and now he is driving, now he's in control of it. If something happened, then can we fix the liability? Yes, we can, right? But then again, the question remains on the privacy part of it. So that's why it's a challenging, very, very challenging time, very exciting time. It's not time to be sleepy at all, because as a lawyers, you cannot sleep. Two things I'll tell you why. One is that you're going to deal with a large, complex system. Humans were already complex. Now this is going to be much, much more complex. Second thing is your profession as a lawyer, right? You're moving ahead to a next level. Your thinking was just open a book and say this section, this part, and this is the law says, and I'll tell you. Now this part, Google can do it. Now the ChatGPT can do it, right? That's done and dusted. If you know the law, and if you think that you can be a good lawyer by just knowing which section of the law is talking about what, your time is gone. It's moved on. Right now, you're not a good lawyer if you just know the if you can interpret the law. The second thing was, I can interpret the law better than anybody else. Even interpretation is now taken care by the ChatGPT and Gemini and all that. The interpretation can be done in a better fashion. You can only be a good lawyer by being a good human now, who can actually connect with other human being and sense it. We see we say that if you can see around the corner, we say, right? Seeing around the corner means if you're interacting with someone, if you can connect with their energy and see what is coming next, that's when you can be a good lawyer. You can't be in this generation after 20, now we're 26, after 2030, if you just believe that I can quote a law and I can fix a liability, I can interpret it, or I can argue. Even argument also is going to be much AI is going to be much better. And when we give the super intelligence, it's going to be in all the space except one space where it will not be better than humans. That human inspiration and spirit, right? That being that good in spirit, connecting with yourself, that self-consciousness, that's the only edge you have. So moving to the self-consciousness, connected to the people, and this is where you need to connect your spiritual roots. Otherwise, you will not get there, right? So without a spiritual root, you'll never get there. You should know about what's consciousness, right? Even to get to the consciousness, you need to know about what is that self thing called self. So that's when you become a good lawyer. So I think there's a lot needs to be done, lots needs to be forgotten. The forgotten aspects of it is that the old fraternity, legal fraternity as it stays today, is like we already call it as in programming languages it's called we have two types of languages, OWL, all we call it as old world languages and new world. Pre-COVID is an old world, post-COVID is a new world. So there is an old world and new world already. BC we used to call it, right? That was BC, before Christian era, and this is after Christian era. Now we have that defining moment here. Before COVID and after COVID is completely different words. So we should all wake up to that. And I think, in terms of ideal data, I've already told you, and privacy is up to you. So thank you.
Well, metaphorically, ironically, the wake-up call has come. Wake up? Well, Sir just spoke about the kind of the challenge. Now, let me tell you, there are tribunals in our country which has got specialized members who are part of those tribunals. Because there are certain subjects where lawyers, I mean, the judges who come from the law background alone will not be able to handle it. That is where we have got the diversities which are put in place. We have got a number of tribunals to that effect. Now, one of the things that can also be mooted is now it's not a more no more a motor vehicle accident claim tribunal. It is more than that. It's a mobility courts or the tribunals that we perhaps may be looking forward to. And when that happens, it will be a bench which will absolutely comprise of a person, a technocrat who is an AI scientist who will be able to deal with it. And then you will have another member who will be a judicial member. I think that's how this kind of a complicated question can ultimately be solved. But please understand, whoever could be the members of such a tribunal, ultimately it is the lawyers who will have to take the brief, go there, argue, place the evidence on record, and come up with a judgment. So that's where the interdisciplinary things that happens today is so much vibrant that I cannot say that I'll be a particular person who would be specialized in a particular domain itself, because there is nothing like a particular domain now, and it's all coming down to interdisciplinary things. That is where, right from the Motor Vehicle Act, I'm going to the DPDP Act, where sir is there online, Devesh Pandey sir. Now he'll be able to tell us how exactly and crucial is this privacy aspect, and is DPDP Act in a position to ensure that the privacy case is being taken care of. Because I remember somewhere that I had spoken about the word of cradle to coffin, but sir has spoken today about womb to tomb. So he's going behind the cradle thing, and he's going to the aspect of womb. If so much of a data is to be taken, sir Devesh Pandey sir, my question to you is how to handle privacy? Is DPDP Act sufficient? Would you moot any changes to the DPDP Act? Over to you, sir.
Uh, it's a very great question, since we are already into this new DPDP and the rules are in place in 2025 itself. See, in terms of data governance, and as sir already said, that we need data to, if you want to prove a case, and we need someone who understands the data itself, because it is true that the person who is trained in law is it is not possible that he must be good in technology. He understands the technology, and he understands the science behind the technology. So it is true that you need someone who understands the technology itself. Now, from the issue with the DPDP Act is how you are going to retrieve that particular data. So first thing that you need to do, that the storage of the data or the data localization should be mandatory. Because otherwise, company is not going to furnish that particular data to you. And in that sense, there is one discussion that is going around, that is right to explanation. So we are no longer be able to sustain in this world with right to privacy alone, because in privacy you are going to protect certain kind of data, which we have the category that personal data and sensitive data, and we have listed these are the things which are sensitive. But things are going beyond those category of data, even if a simple Google, because now companies are personalizing everything. They want to know everything about you, which you even don't know or understand about you. In that sense, they are going there. So simply conferring right to privacy, simple right to privacy, it's like an ornament. It does nothing. It will not protect you. If these machines are going to make decisions for you, you need to understand how they are made. So simply, if a human makes a decision, we ask that human how you reach to the particular conclusion, what factors that you have taken into consideration. So for the DPDP perspective and for the adequate protection, the privacy law is not sufficient. You need to step forward. You need to go with right to explanation. And then there is a saying that nothing on internet can be deleted. So how you are going to ensuring that if someone is want their data to be deleted, how you are going to implement that right to forget? So right to forget, and so from the legislation perspective, it is not idle thing to do that you confer certain right and then you forget about without providing adequate mechanism to it. So we have IT Act from since 2000, but we do not have IT tribunal so far. So it is already 26 years. Okay, so it is not functioning around the country. So apart from going with conferring the right, you also need to provide a mechanism, because every time you cannot go to the High Court and Supreme Court and ask for the right, you need a specialized agency for it. So these are the factors that you need to consider in terms of DPDP, because unless you are going to have that data or stored or localized, you cannot control the activities or you cannot ask them to furnish the data. So these are the point that I think that government need to look before making the policies. Over to you, sir.
Thank you, sir. Thank you so much. At the outset, I would like to thank our distinguished speakers with a big round of applause. Well, what we actually try to do is just to speak about the minutest part of the law and technology. I can only say that this is just to make us to open our eye and to see what exactly is happening. Lot more of questions to be asked, raised, deliberated, and tried to be solved before something really happens on the automated and semi-automated thing to come on our country. We had a very lighter moment just when we were on the lunch, and the distinguished speaker who was there, Mr. Karthik, in the first plenary session. Now, the bags which are all sought to be given was tried to be given to him, and the courteous host said that we will give it to your driver. And immediately he said, who is the driver? There is no other driver. So in that parlance, if at all you see, the concept of the driver has gone now. And now, if at all Tesla has to come to Bangalore, then Thames will have to flow to Ganges. And there is a great saying which says that Thames can come and occupy Ganges only if at all she shows compatibility here. Otherwise, no, will not allow her. Now, the same thing happens here, that Tesla will come here only the moment we are capable of ensuring that the compatibility happens technologically as well as the regulatory framework is kept in place. Now, Cicero had said, the King Cicero, who is very famous for this thing, though the heaven shall fall, let the justice be done, he said that the safety of the people is the motto of law. And let law ensure that the safety is ensured. And yeah, the privacy issue is still to be debated. We have got some right which is now invested in us, that is right to be forgotten. So let's all go to our vehicle and ultimately ask it for some protection and say, please forget where I had been yesterday. Now, thank you so much for the patient hearing. And I need to congratulate my alma mater for coming up with such a great topic today. And a conference on this is the need of the hour. And we are marching much ahead of the times. Let the thought come from all the noble directions. As long as today is concerned, sir, we'll all go manually to our home because it still is capable of happening. Thank you so much. Thank you.
On behalf of Kerry Law College, Bangalore, I extend my sincere gratitude to our chair, Mr. K. N. Nitish, for steering this session with such insight and clarity. I request Dr. Mahantesh sir to please present sir with a token of appreciation. I extend our gratitude to our esteemed speaker, Mr. Chandrasekhar Nagaraju, for his valuable insights and perspective. I request Mr. Tanmay sir to please present sir with a token of appreciation. I also thank our distinguished speaker, Mr. Devesh Pandey, for his engaging and thought-provoking contributions. Thank you, sir.
Thank you, ma'am.
I acknowledge the efforts of the organizing team whose works behind the scenes made this session possible. Thank you, everyone. We'll break for tea.